I want you to imagine a game of chess.
Okay, a game of chess.
Right, but not like your standard polite tabletop match.
Yeah.
Picture a massive, really high-stakes game where the pieces aren't knights or rooks.
They're seats on the United States Supreme Court.
Exactly. And here is where this game completely breaks reality. I want you to imagine that halfway through the match, the players just start actively rewriting the rule book.
Right in the middle of the game.
Yeah. A player realizes they're cornered, so they declare, out of nowhere, that a bishop can now move like a tween.
Which obviously outrages the other player.
Oh, totally. But then a few moves later, that second player retaliates by changing how the pawns work.
And let me guess, there are no umpires.
None. There's just the board, the pieces, and, well, whatever the players can get away with.
You know, that is a phenomenal way to visualize what has actually happened over the last half-century.
It really fits, doesn't it?
It does. Because the United States Senate operates heavily on unwritten agreements, what we basically call norms. And when you strip those norms away, what you are left with is just raw procedural warfare.
Exactly. And the mission of our deep dive today is to map out this specific timeline. We're looking at a dossier called Making the Modern Court, and we're tracing this from 1968 all the way into the 2020s.
So we're not just looking at random news events.
No, we are looking at this history as a continuous, escalating power struggle. Every single move made by one political party basically became the absolute justification for the next even more aggressive move by the other.
But before we map out these moves, we need to lay our cards on the table.
Yes, very important.
This is a crucial ground rule for how we are going to navigate this deep dive today. Today's sources contain politically charged historical events.
Highly charged.
Yeah, involving both left-wing and right-wing political figures. So we need to be clear, we are not taking any sides.
Not at all.
We aren't here to cheer for the red pieces or the blue pieces, nor are we endorsing any viewpoints from the source material.
Right. Our only job today is to impartially report the documented facts from the dossier.
Exactly. We just want to convey the ideas contained in it, helping you judge the history for yourself.
I couldn't agree more. We are just the guides walking you through the machinery of Washington. We aren't here to assign blame or, point fingers at any one villain.
Because, as we're going to see, determining who threw the first punch in this fight entirely depends on what year you decide to start the clock.
That is the perfect setup, because if we want to understand the current makeup of the court,
specifically that 6-3 conservative majority we have today.
Right. We have to answer one central question from the source text. Is this 6-3 result the product of intentional norm-breaking hardball tactics?
Or is it the result of pure, unpredictable fortune?
Yeah, luck of the draw. Or is it simply the ordinary results of winning elections?
It's the ultimate debate.
Okay, let's unpack this. Because to even begin answering that question, we can't start with the most recent confirmations.
No, you have to go back to what constitutional scholars view as the long fuse of the modern confirmation wars.
We have to rewind the clock to 1968.
June of 1968, to be exact. President Lyndon B. Johnson decides to make a major move.
So LBJ's in the White House.
Right. And Chief Justice Earl Warren has signaled his intention to retire. So in response, LBJ nominates Abe Fortas to be elevated to the position of Chief Justice.
Wait, hold on a second. Fortas was already a sitting justice on the Supreme Court, right?
He was, yeah.
So elevating him to Chief Justice sounds like, I don't know, a standard internal promotion. You're just sliding him over to the center chair. Why does this become the first major domino to fall?
Because context is everything in Washington. It wasn't just a simple promotion. First, you have to look at LBJ himself.
Okay, what was his status?
By June of 1968, Johnson is essentially a lame duck president. He has already announced to the nation right in the middle of the turmoil of the Vietnam War that he will not seek re-election.
Oh, wow. So he's on his way out.
Exactly. So immediately, the political opposition sees an opening. Why let a deeply unpopular outgoing president lock in the leadership of the Supreme Court for the next 2 decades?
So there's already blood in the water before Fortas even steps up.
There is. But it wasn't just the lame duck status. Abe Fortas himself was deeply vulnerable.
How so?
He had maintained an incredibly close, almost unprecedented advisory relationship with LBJ even after joining the court.
Like giving him political advice.
Yeah, exactly. Critics argued this was a glaring violation of the separation of powers. You basically have a Supreme Court justice acting as a shadow political advisor to the president.
Yeah, that doesn't look great.
And on top of that, an ethics scandal surfaced. It came out that Fortas had accepted a $15,000 speaking fee to teach a seminar at American University.
Which doesn't sound like a lot now, but in 1968.
It was a massive amount of money. And worse, that fee was funded by former clients and private business interests.
Okay, so you have an outgoing president, a nominee with separation of powers issues, and a financial ethics scandal.
A perfect storm.
Right. That sounds like a recipe for a standard brutal floor vote where the nominee just outright loses. But that isn't what happened, is it?
No, it isn't. And this is where the mechanics of the Senate fundamentally shift.
Okay, what do they do?
The opponents of Fortas, which, by the way, was a bipartisan coalition, it was Republicans and conservative Southern Democrats who were furious with the liberal rulings of the Warren Court.
Right, they teamed up.
Yeah. And they didn't just vote no. They utilized a procedural weapon. They filibustered the nomination.
Okay, we hear the word filibuster all the time, but let's break down what that actually meant mechanically in 1968.
It's important to clarify, yeah.
Because I think a lot of people just picture Jimmy Stewart in Mr. Smith Goes to Washington, standing at a podium, reading the phone book until he passes out.
It's a great image, but the reality of the filibuster is much more structural. In the Senate, there is a tradition of unlimited debate.
Meaning they can talk forever.
Right. To move to a final vote on anything, including a Supreme Court nominee, the Senate actually has to agree to end the debate.
And that agreement has a specific name.
It's called cloture. If a group of senators refuses to agree to cloture, the debate technically never ends, and the final vote can never take place.
So they're basically holding the nomination hostage in a perpetual state of discussion.
Precisely. That refusal is the filibuster. And in 1968, the rules required a massive hurdle to invoke cloture and force an end to the debate.
You needed a supermajority, right?
You did. On October 1st, 1968, the Senate held a cloture vote on the Fortas nomination. They needed that supermajority to break the blockade, but the vote fell spectacularly short. It was 45 to 43.
Wait, they didn't even have a simple majority, let alone the supermajority needed to break it.
Right. And as a direct result of that failed cloture vote, President Johnson was forced to read the writing on the wall.
He had to give up.
He withdrew the nomination of Abe Fortas.
Okay, I want to really highlight why the dossier calls this the long fuse. Because up until this exact moment in American history, the filibuster had been used for legislation, right?
Yes, mostly for legislation.
Most notably, and tragically, by Southern senators blocking civil rights bills. But applying the filibuster to a Supreme Court nomination, that was entirely new, wasn't it?
It was completely revolutionary. The 1968 Fortas blockade was the very first time in history that the Senate successfully blocked a court nominee by using a filibuster.
They took a procedural tool meant for legislative debate and just, weaponized it for judicial confirmations.
Exactly.
It makes me think about the unwritten rules in sports. Like in baseball, there is no actual written rule that says you can't dramatically flip your bat after hitting a home run.
Right, it's just frowned upon.
Yeah, for decades, the unspoken norm was that you just didn't do it because it was disrespectful. And if you did, the next batter might get a fastball to the ribs.
A self-policing norm.
Totally. But then players started realizing, wait, the umpires can't actually throw me out for flipping my bat. It's not in the rule book.
I see where you're going with this.
The Fortas filibuster was the political equivalent of someone realizing that the unwritten norm of giving a president an up or down vote on a nominee wasn't actually a hard constitutional law.
It was just a tradition.
Right. And once they realized they could use the filibuster to stop a justice, the seal was broken. You can never go back to pretending the weapon doesn't exist. So if 1968 set the precedent, how quickly did the other side capitalize on it?
Almost immediately. Because once that norm was shattered, the real-world consequences were huge. The Republicans successfully kept the Chief Justice seat open through the 1968 election.
And who wins that election?
Richard Nixon. And the sheer volume of his impact on the court in the immediate aftermath is just staggering.
How quickly did the ideological makeup of the court shift?
Between 1969 and 1971, Richard Nixon seated 4 justices.
4. In a single presidential term. Wait. How is that mathematically possible in such a short window?
This brings us to a concept we're going to revisit throughout this deep dive: actuarial luck.
Meaning the luck of the draw on human lifespans.
Exactly. Vacancies on the Supreme Court do not occur on a schedule. They happen when a justice retires or passes away. Earl Warren, the Chief Justice, finally retired in 1969. Nixon replaced him with Warren Burger.
Okay, that's one.
Then, Abe Fortas, the man who was filibustered, was hit with another ethics scandal and was forced to resign from the court entirely in 1969.
So Fortas is completely out.
Yeah. Nixon replaced him with Harry Blackmun in 1970, that's two. And then in 1971, Justices Hugo Black and John Marshall Harlan both retired due to severe health issues.
Wow.
Nixon replaced them with Lewis Powell and William Rehnquist.
So within roughly 36 months of the Fortas filibuster, Nixon has completely repopulated nearly half the Supreme Court.
That is a massive shift.
It is seismic. And if we connect this to the bigger picture, the events of 1968 didn't just fade into the history books as some one-off anomaly.
They became the blueprint.
Yes. The Fortas filibuster became a foundational precedent. It was a tactical maneuver that both parties would later look back on.
So whenever someone wanted to block a nominee, they could just point to 1968. Exactly. They could say, the precedent exists, the tool is on the table, it laid the procedural groundwork. But the next massive escalation wouldn't just be about Senate rules.
No, it would be about public warfare. Which brings us to the next massive leap in this historical trend of increasing confirmation volatility.
Moving from the Senate floor to the living room.
Right. If 1968 proved you could use the Senate rulebook to block a nominee, it took another 2 decades for someone to figure out how to use the American public to do it. We jump forward to 1987.
And we are introduced to Judge Robert Bork.
Nominated by President Ronald Reagan to fill the seat vacated by the retiring Lewis Powell. And to understand the magnitude of this collision, we have to understand Lewis Powell's role on the court. He was effectively the swing vote, right?
Precisely. Justice Powell was a moderate conservative. He often provided the decisive fifth vote on incredibly sensitive social issues, including abortion rights and affirmative action.
So his seat was incredibly valuable.
Beyond valuable. Replacing him wasn't just about swapping one conservative for another. It was about the fundamental balance of the court. And Ronald Reagan nominated Robert Bork, who was an intellectual giant in the conservative legal movement, but he was decidedly not a moderate.
So the outcome here isn't just a quiet rejection. On October 23, 1987, the Senate rejects Robert Bork by a vote of 42 to 58.
It is an absolute bloodbath.
But it's not the numbers alone that make this important. It's how we got to those numbers. What was it about Bork that triggered such an unprecedented response?
It came down to his judicial philosophy, specifically his strict adherence to a theory called originalism.
Break it down for us.
Bork argued that the Constitution should be interpreted based solely on the original public meaning of the text at the time it was written. If a right is not explicitly spelled out in the text of the Constitution, Bork argued, it does not exist.
Can you give me a tangible example of what that means for the average person?
The most famous example is the right to privacy. There is no explicit right to privacy written anywhere in the U.S. Constitution.
Right, you won't find the word privacy in there.
Exactly. But the Supreme Court, in a famous 1965 case called Griswold v. Connecticut, ruled that a right to privacy was implied by the penumbras, the shadows of other constitutional amendments.
And they used that implied right to strike down state laws banning the use of contraceptives by married couples.
Yes. Well, Robert Bork openly criticized the Griswold decision. He argued the court had essentially invented a right that wasn't on the page.
Okay, I can see exactly why that is explosive. If you were arguing in 1987 that the constitutional foundation for access to contraception is legally illegitimate, that is going to terrify a massive segment of the population.
And it did. The Bork confirmation fight represents a massive public escalation in how these battles were fought.
Because before this, it was mostly just politicians talking to politicians.
Exactly. Up until this point, judicial confirmations were largely clubby, insider affairs handled quietly within the Senate Judiciary Committee. The Bork nomination, however, turned into a sprawling, multi-million-dollar public relations campaign.
We are talking about literal television commercials, right?
Yes, actual TV spots. Interest groups took out full-page newspaper ads and ran national television commercials against a judicial nominee.
Which was completely unheard of.
Totally unprecedented. The most famous ad was narrated by the actor Gregory Peck, warning Americans about what Robert Bork's America would look like, claiming he would roll back civil rights and privacy rights.
It was a mobilization of public opinion that had never been directed at the judicial branch before. And what is vital to note here, from our sources, is how differently the two political sides viewed this escalation.
Right. We have competing claims of what went wrong.
Absolutely. So how did the opponents of Bork justify it?
Opponents of Bork maintained that they were engaging in a completely legitimate, necessary debate. They argued, look, this man has written extensively that foundational civil rights and privacy precedents are wrongly decided. He is nominated for the swing seat. We have a moral and constitutional obligation to scrutinize his philosophy and vote him down based on his own words.
Okay, so they felt they were just doing their jobs. But the supporters saw it entirely differently.
Supporters viewed it as an unprecedented, bad faith public smear campaign. They argued that Bork was undeniably qualified. He was a Yale law professor and a highly respected appellate judge.
So they felt his resume alone should have gotten him confirmed.
Yes, they felt that taking complex academic legal theories and turning them into terrifying 30-second attack ads fundamentally corrupted the advice and consent process.
They viewed it as the moment the confirmation process became a purely political blood sport.
That's exactly it.
The cultural impact of this specific fight is so profound that Robert Bork's name literally became a verb, to be borked.
When a politician's last name enters the dictionary as a verb, meaning to systematically defeat a nominee through a coordinated public and media campaign, a fundamental shift has occurred in the DNA of American politics.
It signals that the process had left the quiet halls of standard Senate procedure and entered the realm of full-contact opposition research. The gloves were officially off.
And the volatility immediately following Bork is just wild. Look at the chaotic aftermath.
Let's track it. Reagan's nomination of Bork fails in late October of 1987. So Reagan has to pivot. He needs a new nominee, and he chooses an appellate judge named Douglas H. Ginsburg.
But Ginsburg withdraws just days later, on November 7, 1987.
Why? What happened in just a few days?
Over admitted past marijuana use.
Wait, really? A Supreme Court nomination crumbles in a matter of days because the nominee smoked weed as a younger man.
Yes. And it highlights exactly what we mean when we say the process was fundamentally altered. Post-Bork, the vetting process became microscopically focused.
Not just on how they interpret the law.
Exactly. It focused on personal character, background, and absolute purity of history. The national media spotlight was now burning so hot that any perceived flaw could derail a nomination overnight.
But then, to show how wildly unpredictable the temperature of the Senate could be, Reagan pivots a third time. He nominates Anthony Kennedy.
And in 1988, Kennedy is confirmed by a vote of 97-0.
It is a stunning contrast. You go from a brutal 42-58 public rejection of Bork to a rapid withdrawal of Ginsburg over a personal scandal to a unanimous 97-0 confirmation for Kennedy, all for the exact same seat on the court.
It really is jarring.
How does Kennedy get 97 votes in the exact same environment that destroyed Bork?
Because Kennedy didn't have the extensive, controversial paper trail that Bork did. He hadn't written provocative law review articles challenging foundational precedents.
He was a bit more of a blank slate publicly.
Right. He was a conventional, mainstream, conservative judge. And exhausted by the preceding battles, the Senate just confirmed him easily. It perfectly illustrates the intense, erratic volatility of the era.
The process could be a war of attrition, or it could be a breeze, depending entirely on the specific profile of the nominee.
But the pendulum swings right back to conflict just a few years later. We hit 1991. The stakes are raised yet again.
Justice Thurgood Marshall announces his retirement.
A towering liberal icon and the first African-American on the Supreme Court.
President George H.W. Bush nominates Clarence Thomas to replace him.
A young, staunchly conservative African-American judge.
So once again, we have a massive ideological shift at play. But the Thomas confirmation doesn't play out like the Bork fight, does it? The battleground shifts.
It shifts dramatically. With Bork, the battle was over judicial philosophy, originalism versus living constitutionalism. With Clarence Thomas, the battle became intimately, intensely personal.
What happened?
After Thomas had completed his initial rounds of questioning, a law professor named Anita Hell came forward. She presented allegations of sexual harassment against him from their time working together at the Equal Employment Opportunity Commission.
And the result is a nationally televised spectacle that essentially halts the country.
The Thomas Hill hearings were a cultural earthquake. Millions of Americans tuned in to watch incredibly graphic, sensitive testimony broadcast live into their living rooms.
It was just a level of public exposure, of intense and deeply uncomfortable national scrutiny that pushed the confirmation process to an entirely new fever pitch.
And when the dust finally settled, Thomas was confirmed on October 15th, 1991. But the margin is razor thin.
It was 52-48.
At the time, it was the narrowest confirmation margin in over a century.
When you lay this era out, Fortas, Bork, Ginsburg, Thomas, you see a terrifyingly clear pattern. Every single one of these fights, acted as a direct precedent, a blueprint for the next battle.
They all built on each other.
Exactly. The 1968 Fortas filibuster proved you could use parliamentary maneuvers to block a vote. The 1987 Bork defeat proved you could use television and public relations to destroy a judicial philosophy.
The 1987 Ginsburg withdrawal proved that intense personal vetting could sink a nominee in days.
And the 1991 Thomas hearings proved that character assassination, whether justified or not, would be broadcast on live television.
They were sharpening the knives. Each cycle of escalation normalized a level of political warfare that would have been considered entirely unthinkable just a decade prior.
And you can see how both sides felt aggrieved. Both sides felt they were merely reacting defensively to the unprecedented aggression of the other.
Which means the groundwork was perfectly laid. The powder keg was packed. The tensions of the late 20th century were building toward a climax.
And that climax, that unprecedented showdown, brings us out of the history books and into the modern era. The Cold War of judicial confirmations was about to turn incredibly hot.
It begins with a sudden, deeply consequential, inciting incident.
February 13th, 2016. Justice Antonin Scalia dies unexpectedly at a ranch in Texas.
The timing of his death is the critical variable here. It occurs in February of a presidential election year.
We have to slow down and talk about the sheer magnitude of what happened next because the timeline is staggering.
Yeah.
Hours, literally hours after Justice Scalia's death is publicly confirmed, the Senate Majority Leader, Republican Mitch McConnell, makes an announcement.
He states categorically that the vacancy should not be filled by the sitting president, Barack Obama.
Right. McConnell argues that because it is an election year, the American people should have a voice in the selection of their next Supreme Court justice. And therefore, the seat will be held open until the next president is sworn in.
Despite that immediate and absolute declaration from the Senate Majority Leader, President Obama fulfills his constitutional role.
He doesn't back down.
No. On March 16, 2016, he nominates Merrick Garland, the highly respected chief judge of the D.C. Circuit Court of Appeals, to fill the vacancy.
Okay, let's play constitutional devil's advocate here. I want to push back on the mechanics. Doesn't the Constitution say the Senate has to hold a hearing? Doesn't the president have the right to get a vote on his nominee?
That is exactly the argument that was fiercely debated throughout 2016. Let's look at the actual text of the Constitution. Article 2, Section 2 states that the president shall nominate and by and with the advice and consent of the Senate shall appoint judges of the Supreme Court.
Right. Advice and consent. Those exact words.
Yes. But notice what is missing from that sentence. The Constitution does not specify how the Senate must provide that advice and consent.
It doesn't give them a rule book for it.
No. It does not mandate a timeline. It does not mandate committee hearings. It does not explicitly mandate a floor vote.
So there's a loophole.
A massive one. McConnell and the Senate Republicans argued that the Senate was fully within its constitutional rights to withhold its consent by simply declining to act on the nomination.
And what follows is a blockade unlike anything in the modern history of the United States. The Senate holds no hearings. None.
Merrick Garland does not get a committee interview.
They take no vote. They simply do not advance the nomination in any capacity. The nomination sits in absolute legislative purgatory until it officially elapses on January 3, 2017, when the new Congress is sworn in.
That is a span of roughly 293 days where the seat sat open with absolutely no action taken. It is the longest a Supreme Court nominee has ever gone without Senate action.
It's breathtaking in its audacity. Earlier, I used the metaphor of a staring contest, but that doesn't even do it justice. It's more like a pocket veto, but executed by the legislature.
That's a good way to put it.
I mean, the Democrats were sitting at the table, ready to debate, ready to argue the merits of Merrick Garland. And the Republicans didn't just refuse to argue, they walked out of the room, unplugged the voting machines, and locked the doors for 10 months.
It is arguably the most profound demonstration of constitutional hardball in modern American history, using the absolute limits of procedural power to achieve an ideological outcome.
This raises an important question, and it is the single most hotly contested debate surrounding the modern court. When you look at the Bork defeat in 1987 and the Garland blockade in 2016, you are looking at the two events most frequently cited as the original sin of this entire 50-year conflict.
It is the ultimate Rorschach test for American politics. Depending on where you start the timeline, the identity of the aggressor shifts entirely.
Break that down for us. How do the two sides justify their positions based on these events?
Well, if you start the story of escalation at the Robert Bork rejection in 1987, conservatives point to the unprecedented, public, and deeply personal attack on a highly qualified nominee as the exact moment the system broke.
Right, they say Bork was the catalyst.
Yes. They argue that Democrats turned the confirmation process into a political weapon first. Therefore, they argue that the Garland blockade in 2016 was merely a downstream inevitable consequence, a defensive reaction to the aggression introduced by the left decades earlier.
Basically, you broke the rules first when you borked our guy, so we don't owe you a hearing now.
Exactly. However, if you start the story at the Merrick-Garland blockade in 2016, liberals point to the absolute refusal to even hold a hearing for 293 days as the ultimate subversion of constitutional norms.
How do they compare that to Bork?
They argue that whatever happened to Robert Bork, he was at least afforded the dignity of a hearing, a debate, and a final floor vote. Bork lost a Democratic vote.
Garland didn't even get to step onto the floor.
Right. Garland, they argue, was denied the democratic process entirely. To them, 2016 is the true original sin, the moment raw power completely usurped democratic norms.
It is the classic who threw the first punch argument, but stretched out over 30 years of resentment. And the reality is, we aren't here to solve that unresolvable debate.
No, we just need to understand how it functions as justification.
Exactly. What matters for our timeline is that partisans on both sides point to these specific traumatic political events to justify every single hardball tactic they use today. The Garland blockade didn't end the war. It just set the stage for the most dramatic procedural shifts in the history of the United States Senate.
Because the intense boiling pressure from that 293-day freeze directly contributed to the environment that gave us the dual nuclear options.
Here's where it gets really interesting, because this is where the chessboard metaphor comes back in full force.
Yeah.
We talked about players changing the rules mid-game.
The nuclear option is exactly that.
It is the architectural symmetry of the modern confirmation wars. And what is so fascinating is how both political parties utilize the exact same procedural sleight of hand.
To truly understand the symmetry, we actually have to walk you back slightly. We have to look at the board just before the Scalia vacancy occurred. We are going back to November 21st, 2013.
Okay, set the scene in 2013 for us.
The Senate is controlled by Democrats, led by Majority Leader Harry Reid. Barack Obama is in his second term, and Harry Reid is experiencing intense, boiling frustration.
Why?
Because Senate Republicans, led by Minority Leader Mitch McConnell, are using the filibuster aggressively to block a massive number of President Obama's lower court judicial nominees and executive branch appointees.
Wait, they are using the exact same procedural weapon that was first deployed against Abe Fortas in 1968, but they are using it on a massive scale.
Precisely. They are demanding a 60-vote supermajority for virtually every nominee, essentially paralyzing the president's ability to staff the judiciary and his own cabinet.
So Reid decides to break the gridlock.
Yes. In response to this gridlock, Harry Reid and the Democrats decide they have had enough. They invoke what is colloquially known in Washington as the nuclear option.
I want to stop you right there because this is a point of massive confusion for a lot of people. When we say the nuclear option, it sounds like Congress passed a new law. Did the Senate draft a bill, vote on it, and send it to the president to sign to change the filibuster?
No, absolutely not. The Constitution allows the Senate to determine its own rules of proceeding. Changing the rules doesn't require a law.
So how do they do it?
Invoking the nuclear option is actually a piece of brilliant, cutthroat parliamentary judo.
Walk us through the actual mechanics of how it works on the Senate floor. How do you magically change a 60-vote rule into a 51-vote rule?
Here is the step-by-step. The majority leader in this case, Harry Reid, calls up a nomination. Let's say it's for a lower court judge. The Republicans object and demand the 60-vote cloture threshold to end debate.
Standard procedure so far.
Right. Reid then raises what is called a point of order. He stands up and formally suggests to the presiding officer of the Senate that under the current circumstances, a simple majority of 51 votes should be sufficient to end debate.
But the written rule still says 60. So the presiding officer has to say no, right?
Exactly. The presiding officer consults the Senate rulebook and rules against Harry Reid, stating that the rules clearly require 60 votes. This is the trap.
It's a trap.
Yes. Reid then formally appeals the ruling of the chair. He essentially says, I disagree with your interpretation of the rules, and I want the full Senate to vote on whether my interpretation is correct.
And here's the punchline. How many votes does it take to overrule the chair?
A simple majority, 51 votes.
Oh, wow.
So Reid holds a vote on his appeal. The 51 Democrats vote yes, overruling the chair. By doing so, they instantly establish a new binding precedent that ending debate on a nominee only requires a simple majority.
They bypass the written rulebook by creating a new precedent through a simple majority vote. That is the nuclear option.
It's incredibly clever, procedurally speaking.
It is stunning. They use a 51-vote loophole to destroy a 60-vote rule. So in 2013, Harry Reid lowers the threshold from 60 votes to a simple majority of 51. You no longer needed the opposing party to agree to simply hold a vote.
But there was one absolutely crucial detail to Reid's 2013 maneuver. One massive caveat. They explicitly carved out the Supreme Court.
They didn't touch the High Court.
No. The simple majority rule now applied to lower court judges and executive nominees, but Reid left the old rule intact for the highest court in the land. Supreme Court nominees still required the 60-vote threshold to end a filibuster.
Okay, so that is move number 1 on the board. The Democrats changed the rule in 2013 because they are frustrated by blockades, but they leave the Supreme Court protected.
Yeah.
Now we jump forward to April 6, 2017.
The landscape has changed entirely. Following the 2016 election, Republican Donald Trump is in the White House. He nominates Neil Gorsuch to fill the Supreme Court seat left vacant by Antonin Scalia.
The exact same seat that was held open during the 293-day Merrick Garland blockade.
Yes, so understandably, Democrats are absolutely furious. They view the seat as stolen, and they decide to use the one weapon they have left. They move to filibuster the Neil Gorsuch nomination, demanding the 60-vote threshold.
And this is where the mirror structure completes itself. Senate Republicans, now in the majority and led by Mitch McConnell, respond to the Democratic filibuster by invoking the nuclear option themselves.
They execute the exact same parliamentary maneuver Harry Reid used 4 years earlier. They appeal the ruling of the chair, but their move is to remove the Supreme Court carve-out that Reid had left in place.
They extended the 2013 rule change to the highest court in the land.
Exactly. It is incredible to look at this without the partisan spin, just looking at the documented sequence of events. Both parties use the exact same mechanism, the exact same parliamentary trick to shift power and achieve their immediate political goals.
The Democrats killed the filibuster for lower courts because they were frustrated by GOP blockades. The Republicans killed the filibuster for the Supreme Court because they were frustrated by a Democratic blockade.
It is symmetric tactical movement. One side opens the door to procedural escalation, and the other side walks right through it and takes the door off its hinges entirely.
So the both sides framing here isn't just some vague talking point.
No, it's not some lazy false equivalence. It is the documented historical reality of how the filibuster for judicial nominees was systematically dismantled over 4 years.
And the immediate result of McConnell removing that final carve-out in 2017. Neil Gorsuch was confirmed the very next day, on April 7, 2017, by a vote of 54 to 45.
Under the old rules, that nomination would have failed to break the 60-vote filibuster threshold. Under the new rules, 54 votes was more than enough.
With the filibuster completely gone for the Supreme Court, the floodgates were entirely open. The minority party in the Senate, regardless of who they were, no longer had any procedural power to block a nominee, provided the majority party remained unified.
This procedural reality, the death of the 60-vote requirement, is what allowed for the rapid cementing of a new ideological majority on the court over the next 3 years.
Which brings us to the final pieces of this massive puzzle. The rapid succession of confirmations that locked in the current 6-3 conservative majority. After Gorsuch in 2017, Justice Anthony Kennedy announces his retirement.
The man who was confirmed 97-0 back in 1988.
Right. President Trump nominates Brett Kavanaugh.
Nominated in 2018.
This confirmation was incredibly volatile, perhaps the most bitter since Clarence Thomas. Following highly contested sexual assault allegations and deeply polarizing emotional testimony before the Judiciary Committee, Kavanaugh is confirmed on October 6, 2018.
And look at the vote.
The vote is 50 to 48, an incredibly tight margin made possible only by the absence of the filibuster.
And then the final piece in this specific timeline occurs in the fall of 2020. Justice Ruth Bader Ginsburg, a liberal icon, passes away.
And the timing here is a direct echo and a direct blinding contrast to the Antonin Scalia vacancy in 2016. Amy Coney Barrett is nominated to replace Ginsburg, and she is confirmed on October 26, 2020.
The vote is 52 to 48.
But the context is stunning. She is confirmed roughly 8 days before the 2020 presidential election.
Replacing a liberal icon with a conservative jurist mere days before a national election, it was the culmination of decades of procedural escalation, resulting in a solid 6-3 conservative majority.
Okay, I have to jump in here and push back hard, because we talked about the 2016 Merrick Garland blockade, where Mitch McConnell held the seat open for 293 days, specifically arguing that you cannot confirm a justice in an election year.
Right, that was the stated rationale.
And then 4 years later, his exact same Senate majority confirms Amy Coney Barrett 8 days before an election. You don't have to be a partisan to look at that and say, that is the definition of hypocrisy. That is proof the game is rigged.
Your frustration is entirely logical, and it echoes the exact arguments made by legal scholars and millions of voters. The stated rationale of 2016 was completely abandoned in 2020 to achieve an ideological outcome.
It's just a raw power play.
It is. But to understand how scholars evaluate whether the game is rigged, we have to zoom out. We have to look at the data over the entire 50-year timeline we've just discussed, because there is a specific, widely cited statistic from our dossier that attempts to quantify this exact feeling of imbalance.
So what does this all mean when we look at the numbers?
If you count the successful Supreme Court appointments from Richard Nixon's first pick in 1969 all the way through to Amy Coney Barrett in 2020, Republican presidents made roughly 15 Supreme Court appointments.
And Democrats.
Democratic presidents made roughly 4.
Wait, 15 to 4. Let me do the math in my head. Nixon had 4, Ford had 1, Reagan had 3, Bush Sr. had 2, Bush Jr. had 2, and Trump had 3. That's 15.
Correct.
And on the Democratic side, Carter had 0, Clinton had 2, Obama had 2. That's 4. 15 to 4. Over a 50-year period where control of the White House and Congress swung back and forth relatively evenly, one side got nearly 80% of the Supreme Court seats.
It's a massive number.
When you hear that, your brain immediately screams, hardball, manipulation, the board is tilted.
It is a striking disparity. But the historical record insists that we stress test this statistic. We have to unpack that 15 to 4 disparity with some vital, complicating caveats, because numbers without context can be deeply misleading.
Okay, give me the caveats. How do you explain a 15-4 blowout?
The first caveat is what scholars refer to as the luck of the actuarial draw.
Actuarial luck.
Yes. Supreme Court justices have lifetime tenure. They do not serve terms. Vacancies do not occur on a schedule. They arise unpredictably through retirements or, as we saw with Justices Scalia and Ginsburg, through death.
Right. You can't plan for it.
Exactly. There is no predetermined rhythm to when a seat will open up. A president might serve a single term and see multiple vacancies, like Nixon seeing 4 in his first 3 years, or Trump seeing 3 in one term.
Well, they could get nothing.
Or a president might serve a full 4-year term and see absolutely 0 vacancies, which is exactly what happened to Jimmy Carter. Carter simply had the bad luck of nobody retiring or dying while he was in office. You cannot engineer actuarial timing.
Okay, I hear that. You can't appoint a justice if nobody leaves the bench.
Yeah.
What's the second caveat?
The second major caveat is the most fundamental reality of the American democratic system. Presidents ultimately earn the right to make these appointments by winning elections. And if you look at the specific years when those unpredictable vacancies arose between 1968 and 2020, Republicans simply won the White House at the right times.
They dominated the 70s and 80s.
They did. You cannot appoint a justice if you don't win the White House. It's a harsh truth, but it's the foundational rule of the system.
Winning elections matters.
Exactly. And the third caveat is perhaps the most nuanced but historically significant. Today, we assume that a Republican appointee equals a conservative vote and a Democratic appointee equals a liberal vote.
Which feels pretty true right now.
It does today. But historically, the party of the president who appointed a justice did not always serve as a reliable predictor of how that justice would vote on the bench. We call this ideological drift.
Right. The history is full of justices who surprised the presidents who picked them.
Absolutely. The dossier specifically highlights justices like Harry Blackmun, who was appointed by Nixon but authored Roe v. Wade. It highlights John Paul Stevens, appointed by Ford, who became the leader of the court's liberal wing. It highlights David Souter, appointed by George H.W. Bush, who reliably voted with the liberals, and Anthony Kennedy, appointed by Reagan, who served as the swing vote on gay rights and abortion.
All appointed by Republicans.
All of them were appointed by Republican presidents, yet over their tenure on the court, they moved significantly left of expectations.
So what you're saying is that simply counting 15 appointments by Republicans doesn't neatly translate to 15 lockstep conservative votes over the last 50 years.
Correct. The historical reality of judicial independence and ideological drift complicates the narrative that the 15-4 statistic represents a perfectly engineered, unbroken, conservative monopoly.
Okay, here are the caveats. Unpredictable timing, the raw reality of winning elections, and historical ideological drift. But I want you, listening to this, to ponder this tension.
It's a really important tension.
Think about the Garland blockade. A seat held open for 293 days. And the Barrett confirmation, pushed through in 8 days. Both actions were, strictly speaking, entirely within the constitutional rules of the Senate.
The Senate has the power to withhold consent, and the Senate has the power to vote quickly.
Right. But is it possible for something to be entirely within the written rules, yet completely shatter the system's prior expectations? Is it fair play within a tough system, or is it norm-breaking hardball that undermines the legitimacy of the institution?
What's fascinating here is that reasonable, deeply informed legal scholars genuinely dispute the answer to that exact question.
They don't agree.
Not at all. They look at the 15-4 statistic, they look at the entire timeline we've just mapped out from the Fortas filibuster to the twin nuclear options, and they genuinely disagree on what it proves.
That are the options.
Well, does it prove a deliberate, manipulative scheme by one side to capture the court through procedural warfare? Does it merely reflect the chaotic luck of actuarial timing? Or is it simply the ordinary, predictable reward of one political coalition winning the right elections at the exact moment a justice happened to retire?
It's the core tension of the whole history. Every action has an equal and fiercely debated reaction. You can build a completely rational, fact-based argument for any of those three interpretations.
And that brings us to the present moment, because regardless of how we got here, the rules of the game have fundamentally, irreversibly changed since 1968.
The board is different now.
It is. The intense vetting processes, the highly sophisticated opposition research, and the deeply sorted, polarized nature of our modern political parties mean that today the appointing party does predict a justice's votes far more reliably now than it did in the 1970s through the 1990s.
So no more ideological drift.
The days of a David Souter genuinely surprising the party that appointed him seem incredibly unlikely in the modern era. Because the vetting is so extreme, there are no more surprise wildcards slipping through the cracks. Every single open seat is now viewed as a guaranteed generational shift in power.
Which leaves us with a final, deeply provocative thought. A question not entirely resolved by this historical discussion, but one we must consider as we look to the future.
What is it?
If the process is now entirely devoid of the 60-vote filibuster buffer, if a simple majority can push a nominee through, regardless of the minority's objections, and if the ideological lines are more rigid than ever, what happens when the next unpredictable vacancy arises?
Have we reached the ceiling of this escalation cycle? Have the political parties finally run out of procedural norms to break, out of unwritten rules to exploit?
Is there any escalation left short of fundamentally altering the size of the court itself?
Or is the tactical, bare-knuckle warfare we've discussed today, the weaponized filibusters, the 293-day blockades, the nuclear options, the hyperpartisan confirmation votes, simply the new permanent machinery of the United States Supreme Court?
Is this just how the game of chess is played from now on? It really makes you look at that board differently. We've spent this deep dive tracing the path from the Abe Fortas filibuster in 1968 all the way to the confirmation of Amy Coney Barrett in 2020.
Covering a lot of ground?
A ton of ground. We've explored the complex constitutional theories of Robert Bork, the deeply personal battles of Clarence Thomas, the constitutional staring contest over Merrick Garland, and the parliamentary sleight of hand of the twin nuclear options.
We've seen how the timeline operates as a continuous, escalating power struggle,
where every single cycle, every broken norm, serves as a hardened precedent for the next battle. We have laid out the documented sequence. We have shown how the rules were rewritten while the match was still in progress.
And now it is entirely in your hands.
Thank you so much for joining us on this deep dive. Our mission today was to lay out the board to show you how the pieces moved and the rules changed over the last 50 years.
We encourage you to look at this history, weigh the facts, explore the caveats we discussed, and decide for yourself.
Was the modern court forged by hardball tactics, by the unpredictable luck of the draw, or simply by the ordinary results of winning elections? Because the game is still going, the pieces are still on the board, and the next move, the next paradigm shift, is always just one unpredictable vacancy away.